This lesson is about how the Supreme Court hears cases. The Supreme Court has both original and appellate jurisdiction, meaning that they can hear cases that are brand new or cases that have been heard before, respectively. However, the Supreme Court's original jurisdiction is limited to disputes between states and the like, and they rarely use it, so for now let's pretend it doesn't exist. While original cases focus on the specifics of a case according to laws already in place, the Supreme Court's appellate jurisdiction tries the laws themselves for constitutionality and interpretation. We learned in previous lessons that there are 3 levels of courts: district courts, circuit courts, and the Supreme Court, and that the Supreme Court is, well, supreme. So the Supreme Court looks at cases from the lower courts that have been appealed. The only problem is that there are 7,000 petitions for appeal filed to the Supreme Court every year. To deal with this, they rely on the age-old solution of letting harried subordinates do all the dirty work. In this case, young lawyers draft pool memos, which are basically a summary of the case and their opinion on whether or not it should be heard. When deciding whether to hear a certain case, the Supreme Court relies on the rule of 4, or that 4 out of 9 justices, 1 less than the majority, have to want to hear it. If they vote to hear the case, the Supreme Court will give the lower court a writ of certiorari, which is basically an order to the lower court to give them all the case info. Interest groups can influence a Supreme Court case by filing amicus briefs, or literally, friend of the court briefs. These are documents with evidence and arguments for the position that the interest group wants the court to take. Of course, like pretty much anything else, the more money the group has, the more likely they are to gain influence. The Supreme Court also hears oral arguments in a formal debate format, where they can ask the proponents of each side specific questions about the case. After hearing the oral arguments, the justices meet and vote in complete secret. We don't know much about this stage, but we do know that there needs to be a certain amount of cooperation to come to a majority opinion, and that the Chief Justice is often instrumental in achieving this consensus. Our current Chief Justice is the relatively conservative John Roberts. Once a majority is reached, either the Chief Justice or another justice of his choice is charged with writing the opinion of the court, a document explaining the majority ruling. However, not everyone in the court may agree with this opinion. Another justice may write a concurring opinion, which agrees with the ruling of the court, but for different reasons than those stated in the official document. A justice from the minority bloc may write a dissenting opinion, or an opinion that directly contradicts the majority opinion. Now, it's time for some multiple-choice questions! Question 1. An amicus curiae brief is filed in order to 1. Indict an elected official on corruption charges. 2. Influence the outcome of a Supreme Court case. 3. Force a lower court to carry out its judicial duty. 4. Disclose contributors to a political campaign. Or 5. Help a minor party candidate appear on the ballot. Ready for the answer? There's actually no way for you to answer that. This is awkward. Okay, so the answer to number 2, to influence the outcome of a Supreme Court case. Right. Next question. Question 2. The rule of 4 refers to 1. Bureaucratic guidelines for the provision of federal matching funds. 2. The Senate bylaws governing the invocation of cloture to end a filibuster. 3. The constitutionality test for a law infringing free exercise of religion. 4. The criterion according to which the Supreme Court grants certiorari. 5. The principle that a bill may become law even if unsigned by the President. And the answer is number 4, the criterion according to which the Supreme Court grants certiorari. And finally, question 3. If a justice agrees with the decision issued by the court but disagrees with the court's reasoning, there tends to be 1. A concurrent opinion. 2. A dissenting opinion. 3. An opinion with reservations. 4. A writ of certiorari. Or 5. A brief. And the answer is number 1. a concurrent opinion.